Suit out jogging.
All you can do is cope with it, civil pass.
Yeah. But no, this Arctic spell, we didn't get, I mean, we got cold a little bit, but not anything like much of the country. Yeah.
Rebecca, are we waiting for Ed?
He's on his way, but we have a quorum, so it's up to you.
We can do business.
All right. Nancy's spoken.
Oh.
Meg, are you recording?
Yes.
All right, I will call this meeting to order. This is the State Records Committee. It's Thursday, January 18th, 2024, and it is 9:03 a.m. So while we wait for Ed to arrive, we'll just go on with the business. So the first item is the approval of the January 4th, 2023 minutes. Are there any comments on the minutes or a motion?
I'll make a motion to approve the minutes.
I'll second that.
Okay, we have a motion to approve the minutes from Nova and a second from Linda. All in favor, say aye.
Aye.
Any opposed? Okay, that carries unanimously. How about Rebecca, you okay with SRC appeals received and declined?
Okay. It's here.
We have not had any appeals denied since the committee last met. We have 4 that have been withdrawn. And then for April, we're up to 1, 2, 3, 4, 5, 6. This last one, Mark Steele versus the School Activity Eligibility Commission. I'm not actually clear who the respondent is. I think it's the Board of Education, but they say this commission belongs to the Attorney General's office. And so I've scheduled the hearing. I talked to the attorney who answered the request and directed the requester to appeal to the committee. And I also have scheduled a meeting with the AG's room specialist and education's room specialist, so we can figure out where they belong and notify the respondent. So the attorney that answered the request and represents the board has been informed that there's a hearing, but the record officer, the attorney assumes that that's him, and we don't know who the CAO is. So, but I've scheduled a hearing, and hopefully with some of my colleagues, we can figure out where it actually goes. Archives and the public notice website has it listed under the Board of Education. I think that's where it belongs. It's an education statute, and we just might need to talk to their record officer and let them know that. So I have another hearing appeal that I haven't scheduled yet that's similar. It's with the Labor Commission. The record officer, I think, I'm not clear if they answered the request or not. I think they provided the records, but the CAO answered the request and directed the requester to appeal to the committee. And instead of appealing to the CAO, who's the same person who already answered, it's had a couple of weird process appeals. So that's what's going on over here. But no appeals have been denied since we last met. I guess that's it.
Thank you. All right. We have a quorum. It's here. Everybody's here. So we could go on with the first hearing, and it's Alicia Ellington and the Department of Health and Human Services, and it's a continuance of hearing 2023-122. The record.
You want to go on camera?
Okay, we have a motion to go in camera from Nancy. Anyone opposed to that motion?
I'll abstain.
All in favor of going in camera? People deliberate? No.
No.
To discuss the in-camera review, then we'll come back for deliberation. All in favor, say aye.
Aye.
Hey, you're in camera.
Maria, I'm gonna email you a link right now.
Okay. I'm gonna log off here, because my camera can't do two.
Is it this one? We're gonna be in that one.
Till 10
not that one
o'clock.
down there.
Till 10.
Everybody back and connected? Rebecca, you recording? Okay, we are back in open sessions. And we are in deliberation. So anyone would like to begin?
I'll start. Having reviewed the records in camera and spending quite a bit of time going over them and the classifications noted by the governmental agency, I do believe these are employment records and that they are classified correctly under private. I don't agree with the classification of investigative records. I think it's just going through some processes. Most of the emails are just going through the processes. There are like 4 pages of attorney-client privilege and work product, 305, 17, and 18. The draft that is the attachment to those attorney-client privilege documents would be protected under 305.22. However, I would note that in 2021AI, it says that upon request, a private record should be disclosed to the subject of the record. And so I'm of a mind that most of these records should be provided to Miss Ellington, given that she is the subject of the record. The attorney-client ones, we looked at Southern Utah Wilderness Alliance. It says that there has to be an attorney-client relationship, the transfer of confidential information, and the purpose of the transfer was to obtain legal advice. There's only about 4 pages that are that. Like an email that says, hey, can we meet on a call today is not attorney-client privilege in my opinion. That's how I've looked at the records, and I don't think there's any weighing because I think she's entitled to access to private records about her. Anyone else want to add anything?
Well, I just think that your last statement, Nancy, is key. That she's the subject of the record. She's seeking records about herself and about the process that, you know,
I am good with the motion and I would like to second it.
Can I seek clarification?
But I haven't made a motion yet.
It sounded like one, Marie.
I have a question. I'm sorry, I've forgotten your name.
Blaine.
Yeah.
Blaine, sorry, Blaine. So the assertion of protected, or excuse me, private, you were just asserting Ms. Ellington, correct?
No, that's not correct. So as stated in the statement that I made, all of these records are likely private records concerning a government employee. So if somebody else requested them, they wouldn't get them. The only records that are considered private are records that Ms. Sanchez, the GRAMA coordinator and records officer, confirmed are regarding another employee. They were false positives that came up with the poll. So everything that the department has classified as private, she has, the department also agrees that she's entitled to anything that is considered private. Also, if I made the motion or the discussion didn't address work product, which most of these records are also work product. I just want to.
But they're not with the attorney. They're with DHRM and DHHS, and work product is specific to the attorney-client privilege.
So do you remember the details? So the other employee, you talking about the one that they essentially used that letter from that situation as a template for this situation? Is that what you're referring to in terms of other employees' privacy? Because and I don't even know that in that case, that employee was named. Remember they used it as a template?
So in the index that was provided, I don't know about the template question. It's been a while since I've seen these records, but wherever it indicates on the index that they were private concerning, on the index, it'll have 302, 2A or 2D next to it, and it'll have the page numbers. And if I may, I know you're in deliberation, the work product. If I can address that. Okay. So the work product, it's not called the work product doctrine. I mean, it's basically somewhat of a codification of case law, but the statutory language is specific where it says, it doesn't just say an attorney, it says an attorney, and there's a list that includes employee, and it's in preparation, in anticipation, or what's the other, but there's specific language on the statute.
Administrative proceeding.
Yes.
They're going to be an administrative proceeding.
So that information would be, unless the committee rules otherwise, that information would be considered either protected as an investigative record or work product, because if it's in preparation for any potential proceedings, and any employment action or anything like that would be an administrative proceeding.
Yeah.
What code would that be?
I believe that's 305.
18.
Yes.
And we did use that remember that playground case?
Oh, yeah.
But they proved there was an anticipation of litigation. And can I just speak to the redactions a little bit? I know you don't do the redactions, but I would really like, even if we went with the body of the emails and said, okay, yeah, we're going to agree with you on work product, like, you should only be redacting the parts that have information, not email addresses that are public, not all of the parts of the email that say, hey, this is a protected document, all that. It just makes it so much harder for the person who, when they get it and they see all these redactions, and really all that needed to be redacted was 2 sentences, right? So if you could just pass it on to your records officer to, not just swoop, oh, we're gonna, even a copy of her records request, which was an attachment to an email, is redacted. I mean, it's just.
So I think it also gives the impression that there's a ton of records that Ms. Ellington is not able to access. And obviously a lot of it is duplication, because you have to go through the email strings. But the other thing is that kind of thing being redacted leads to the impression that there's a ton of information she doesn't have. And when you drill down to this, there's actually a small amount of information compared to the number of pages that is relevant to this case.
I have some relevant information related to that. I can't discuss anything that occurred in mediation, but an email was sent before the hearing to Ms. Ellington with a list of, so it included notes, and it said these are all, for example, a large part of the redactions included, what's the word for it? Like a confidentiality statement at the end of an email. Yeah. And so it explained to her where those were. And the reason that those were redacted is because different employees may have different confidentiality statements. And so it could indicate who was part of the conversation. And if truly protected under the work product doctrine, then the department's understanding was that the people participating in the conversation is also protected information. So that's the department's reasons, whether or not the committee agrees with that.
I think that's really stretching the definition of work product to suggest that anybody involved in the conversation is also covered under that. the actual content, yes, I would understand that as a work product. But the identity of these people, I don't think that's what grandma would have intended. Particularly where they're obviously operating in their official government function.
I don't see, even with the argument being made here, I don't think it arises to the requirements of Schroeder versus Utah, does it?
Well, I think is Schroeder specifically about attorney-client?
I know,
Schroeder has
isn't that what we're talking about?
some. Southern Utah Wilderness has the 3 prongs.
Yeah,
Schroeder discusses a little bit of the work product doctrine, what constitutes that with an attorney.
With an attorney, though,
Yeah.
specific about an attorney.
Yeah,
Where
that's-
this work product encompasses employees.
Yes, Glenn's talking about the non-attorney work product, correct?
So your analysis is under section 305.18, whether those were prepared in anticipation of some kind of proceeding, judicial or administrative. And then you have the wing analysis.
And then we can weigh,
Because it's 305.
because 305.
Well, not knowing the inner workings of that department, we could determine if there was going to be an official proceeding. Because, okay, they prepared a document back and forth and whatever. And my understanding following it is they then just gave it to her. There was no official proceeding, was there? Or has there been, I should say.
I don't believe that would be information that could be shared, but there's always an opportunity whenever anything like that is given for an appeal. And so there are potential proceedings in response to that.
If there were proceedings with the appeal period be expired yet.
I don't know.
Yeah, I'm very uncomfortable when we start going into potential, possible maybes. There is nothing on the planet that cannot be the subject of litigation under certain circumstances. I think we have to try and keep it much more closely defined. And the possibility that there might be at some point an appeal, litigation, proceeding, I believe if it's not the normal standard, then this section of grandma does not apply. Is my personal opinion.
Can I make another comment? And I apologize for
this is helpful. This is clarifying.
So as you review the records, you may have seen some language such as we're intending, or we're thinking about doing this. And so another piece of information that was shared in the last hearing, so I think it would be, and in the appeals, Ms. Ellington referenced certain complaints that she may have made. And so that would be information that, while normally private, she shared in the hearing, such as UALD or EEOC complaints.
But they weren't referenced in the records we looked at.
No, but that's what his argument is as to work product.
Oh, I see.
Right, if there's an EEOC complaint, then these would
anticipate that.
I still disagree. I think we can tie ourselves up in knots if we try to make the ramifications of grandma that broad. That we have to stay somewhat close to the language. And if it said ever or any potential, but it doesn't.
Well, it's for or in anticipation.
Well, in anticipation is kind of like the OCMA reasonable imminent litigation thing.
Yeah.
Yeah, I mean, I think in anticipation is of reasonably imminent litigation,
Well,
not
I
any
think that's what-
litigation ever.
His argument is that she's already said she's made a complaint to the EOC, which would mean there would be an administrative proceeding.
Okay, but did she say that after she requested the records? Because we have to base our decision on her original request, not what she may or may not have done subsequently, right?
The requester is online if you would like me to give her speaker answer questions.
Do you feel like that significantly changes things, Nancy?
I don't
Enough
know,
to
I'm
hear from
still,
Ms. Ellington?
I'm still working
Yeah.
through that in my, Ed hasn't.
I believe it has changed with me, so from what we saw in cameras.
Janet Pankos.
Me forgetting about 18 and just thinking that was attorney-client. I believe what I saw in camera to me does show that there are employees talking about potential administrative proceedings. I believe that.
Okay, when you say you think they're talking about potential administrative proceedings, you're not talking about Ms. Ellington saying that she's already filed complaints. I mean,
No, I believe.
what is the official department procedure if a letter like this is issued? Is there an administrative hearing?
Well, I don't know if they're, in my opinion, I don't know if it matters.
Well, why?
Because they're having what I believe that I saw or interpreted was they're having conversation.
But it says
anticipating that there's going to be an administrative hearing or an administrative procedure.
But if the department does not have an administrative
It doesn't say they
procedure,
have to have it. It says they're anticipating.
well, you can anticipate if it's not their policy. If this is not how they handle something, they're not gonna come out of thin air with an administrative proceeding. That's what I'm asking Blaine.
So
is there an administrative proceeding normally in a situation like this?
In a situation, that's difficult to answer without disclosing private information. However, there have been administrative complaints with an EEAC and UALD complaint. When there is an administrative proceeding, if I, as a reminder, as discussed in the last hearing, grandma is separate from discovery, and in proceedings, there is a separate avenue for people to request things such, and, in lawsuits, there's an avenue to request things such as communications, and then attorney-client privilege and work product doctrine as applied by the courts and case law applies to those proceedings. But generally, people get more under discovery than they will get from a grandma request.
I have a problem with this argument. I have a problem with this argument every time it's brought forward, because it's brought forward by attorneys, and ordinary people may have an avenue, but in most cases cannot afford to pursue that avenue. And so for it to be considered an avenue just like anything else is unacceptable to me. I think grandma has to stand independent of any discovery, any litigation, and maybe she can get something else in litigation, but that's irrelevant in terms of grandma. So don't give me this she has other avenues argument. She doesn't have to have other avenues under the law for you to fulfill her request. Either the law fulfills her request or it doesn't. It's not colored by whether she has other avenues or not. That's just completely unacceptable.
Rebecca, can we bring Alicia in?
Yes, absolutely.
Is that okay? Sorry.
Yeah. It'll be good to hear from her. She may have some light to shed on this discussion.
Ms. Ellington, can you hear us okay?
I can.
Ms. Ellington, I have a question. So, and I'm trying to remember what you said about 2 weeks ago about, did you say you had filed a complaint with the EOC and ULD? It is.
So I did prior, but I don't have, those complaints are no longer with the EEOC or UALD. And it was mostly just trying to get my records that I feel like I'm entitled to, and going through all of this just was my main reason for it. I just like I said, I was asked to sign something, and I just wanted to see how it was being directed and handled. That was it.
So when you made your first request for this information, had you filed any of those actions?
No.
I think then that's irrelevant.
If she had not, she had by the time she filed her appeal. It's mentioned in her appeal documents.
That was from something prior that's totally unrelated.
Thank you.
Any other questions? Ed's comment interesting because I think, Ed, and correct me if I'm wrong, but
Chair, I can't hear you.
I think are you saying like there's always this anticipation on the subject of the record that some type of administrative function is going to happen, whether it's a formal hearing or.
I'm not sure if I would say there's always anticipation. I'm just saying what I believe, or my interpretation on what I saw there. I believe there is definitely language in there that they're anticipating there's going to be
Something.
administrative
Some type of
proceedings. Correct.
And we don't know if at what level that is.
I agree. There is some language.
Do you believe that would cover the whole, the body of, I mean, obviously there's emails that are saying, hey, when can you meet, whatever. Do you believe that would cover the body of their discussion?
That's why I asked the question, that is because I think, can you have a meeting? Can we discuss this? Like, to me, that's all administrative. That's administrative function happening.
Sure.
It's not a formal hearing.
Right. So, yeah, so I'm not saying that we had to go back and look and see everything. There's probably stuff in there that I would be comfortable with in unredacting, but I do believe when we left in camera, there were things that I thought, yes, this clearly should be given. Now, reading this and then having that brought to my attention, now I changed that. I think there are things like that. That's just that. All under 305.18. Maybe not all of it, but definitely more than what I thought coming into this discussion.
So
Ed, can I ask you a question?
go ahead, Marie.
So do I understand what you're saying is that, or would it be appropriate to interpret what you're saying is that there should be some redactions, but not as much as currently? Or are you saying that you're more comfortable with the redactions as is?
I think it's fair to say your first statement, but I don't know which ones I would be comfortable with unredacting without looking at it again.
Yeah, but that's not our job anyway. But
Yeah.
But
there's probably some minutia type stuff that's in there that doesn't need to be redacted, that is redacted. I'm just saying that coming in after in camera, I thought that there was going to be release all of it except for these 4 pages. I do not feel that way now.
So are we moving towards saying, I mean, it's not like we're going to say unredact this and this and this, but are we getting more comfortable with saying the redactions are too extreme, and that the document should be let's see, how would I say this? The respondent should go through the documents again and with an eye to fewer redactions, but specifically be careful around attorney-client privilege. Is that where we're getting?
I feel like technically that would be true, but the reality is the things we're talking about unredacting are of no value to Ms. Ellington. They're basically things like, hey, can you meet on this day? Oh, I wasn't available yesterday, I can meet today. It's going to hold this whole thing up for Ms. Ellington to end up getting unredacted information that is totally worthless to her. So in this particular situation, I don't know if there's any value to Ms. Ellington in that.
So, and can I ask you a question? Because she testified at the first hearing and then again today, what's of value to her, at least what's of value to her is to see that administrative process happening. Not necessarily the specific information, but to her, there is this value of seeing how the government handles the case. And since she's the subject of the record, there's a high value to her for that type of information.
Does it change? Question for everybody. She just said that those. She was closed.
You can reopen that. I don't know how that's the point.
Yeah, and she said that that. So does that change our?
I mean, it's a good question, and hearing her say that she wants to see that process, that government process, and handling her situation.
Well, and
is of value to her.
then does it for the respondent in terms of the appeal? Is it a matter? Do we need to know when those things were closed?
This may help the committee. If that's okay. So some of the records were considered investigative. And I know the committee has already spoken to that. The department considers any investigation that has already terminated or closed, that is no longer protected under 10A. So that was considered when Ms. Sanchez classified the records.
So is that attorney to speak for there's an ongoing investigation?
Can I ask about, Brian, the preponderance of evidence, does that only apply to attorney-client privilege, or does it?
And work product.
And work.
The work product of the attorney or the employee? We're talking about the work product of the attorney.
Right, says both.
Anything under subsection 18.
Okay.
So Mark's comment or question, would it be fair to say we would properly classified under 18, or that's the code that we're using, and now it turns into a weighing process? Okay.
And I'm much more comfortable going there.
Is that where you're going?
Is based
weighing
because
the value to Ms. Ellington and the public of seeing the process on one side of the weight versus.
In this case,
Well, I don't think the public is going to get the private record.
True.
We've said that it is classified as private.
Yeah, that's true. Ms. Ellington.
And only Ms. Ellington can see it. So it's Ms. Ellington's interest. And, are her interests greater than the state's? That's what we're really looking at. Equal to or greater to the state's.
and
In this particular case.
In this case.
And after the review of the records, I think we identified that section that is definitely private and should stay redacted. And I mean, that's where you were headed, Nancy.
If we want to include that section in a motion, how do we describe that section?
The attorney-client privilege or
Yeah.
the private?
The attorney-client privilege,
The work product?
It's those 4 pages.
Well, if we believe that there's work product there and that it was created in anticipation of an administrative proceeding, I don't know litigation or not, but I certainly believe that could have been prepared in the anticipation of an administrative proceeding. Personnel issues are usually, they get to that level. Then the records are classified correctly, and then we determine if the preponderance of the evidence or the weighing gives her a greater need to have access than the state does to have protected.
At least equal.
At least equal to.
Can I read a portion of the statute that I think is relevant on the committee's weighing interest? It says, except as provided in sections, I'm in 11A of 63G2 403, 11B. Except as provided in 63G 204-6, which will apply to anything for investigative records, I believe work product and attorney-client privilege. The state records, and that has a different standard, but the state records committee may, upon consideration and weighing of the various interests and public policies pertinent to the classification and disclosure or non-disclosure, order the disclosure of information properly classified as private, controlled, or protected if the public interest favoring access is greater than or equal to the interest favoring restriction of access. And the department argued that Ms. Ellington hasn't presented a public interest. She's presented a private interest in the records, which is where that's more of a discovery issue, but thank you.
See, maybe that's where Ed's at or was. I don't know. I don't want to speak for you, but you know, it is more of a private issue because the public is not going to get access to these records unless she gives them, chooses to waive her rights to privacy. And
Yeah, but we've had several cases before where that was really fuzzy in terms of public.
I think we're clearly not going to agree on this.
Yeah.
I think we're ready to at least try a motion and see how far we can get with it. Maybe not.
Try one, Marie.
try one.
I'll try one.
Okay.
Yeah.
Okay.
Would make a motion to no, I can't deny the appeal. That the records are properly classified as private under 305-18.
That's work product. Here, you want my list?
The long list, Ed.
You could just say they're properly classified.
Okay, that they're properly classified. And do I have to use, because to me it's 305-18, that wording in 305-18, that's it, that it was employees in anticipation of administrative proceedings and that the public interest, that there is no public interest from 403-11B. That it's not a public interest, it's her interest, not a public interest.
I'd second that.
work?
Okay, we have a
That address
motion.
the weighing in. Does that address the weighing in for you if that goes through?
We have a motion from Ed to deny the appeal and a second from Nancy. So is there any discussion to the motion? Okay, we'll take a roll call vote. We will start with Marie.
I'm thinking, I think I'm going to vote no.
Marie's a no. Mark.
I was hoping they'd start over there.
Chair privilege.
Yeah, I know. Aye.
Linda.
No.
Nancy.
Aye.
We gotten through everyone?
Did you do it?
Yeah, Ed and
Ed.
you.
Aye.
And Nova, did Nova vote?
She was not here for the first hearing.
Oh, okay.
And I vote aye. So the motion carries 4-2. So we'd like to thank the parties for their participation and their responses to our questions. We appreciate it. That's not been an easy hearing. So the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And either party may appeal to district court within 30 days of the date on the order. Okay, thank you, Blaine.
Thank you.
Okay, the next item on the agenda is Brady Eames and the Utah League of Cities and Utah League. Why not? Utah Government Trust.
Oh,
There it is.
yeah.
It's hearing 2023-130. And are we okay to saunter for a couple minutes, Rebecca?
Sure.
Okay, will you? Recording is started, so we are back in open session. The next item on the agenda is Brady Eames and ULGT. It's hearing 2023-130, and Mr. Eames is requesting electronic access to a bond policy and liability policy. And then the respondent asks the requester to go to the office to view the records. So, Mr. Eames, you've been before us, the
Chair,
committee before.
I reached out to the respondent to ask him if he's going to be coming. And he says no. So I provided Brady with what he requested, please see attached. And we're happy to give him anything as long as it's not protected, as long as we understand what it is that he wants. We won't be there, it's a waste of time. The attachment is an email thread from this morning, looks like, that says, Brady, this is the most comprehensive response I can give you to your request. And there's a 69-page attachment of a policy, looks like.
So Mr. Eames would already have that and have had a chance to look at it, to see if that's what he requested.
Right. It looks like that was sent at 8:49 this morning. So we have no respondent for this hearing.
So without a respondent for the hearing, I haven't seen this one before. And they just provided the records.
Did they provide the record he asked for? We don't know.
A good question.
Can we at least ask him if that's what he asked for?
Please.
Will you ask Mr. Eames that question?
Mr. Eames, are you there?
He's muted.
Mr. Eames, you're on mute.
There he is.
Mr. Eames, are you there?
Good morning. Good morning.
Morning. Have you had a chance to look at that
Good
document?
morning. I'm here.
Mr. Eames, can you hear us okay?
I'm here. I'm up here in Logan.
We have a question.
Yes, I can hear you okay.
Linda would like to ask you a question.
Mr. Eames, they sent you an email at 8:49 this morning. Have you had a chance to look at it and see if that's what you requested?
Yes, I acknowledge that email, and it's absolutely what I requested. And so at this point, I'll withdraw. I don't know, withdraw the appeal or
Brian, do we handle this?
Denied appeal, or you can withdraw if you don't want.
at the last minute because the records were provided to me at the last minute.
Great. Thank you, Brady. So I would make a motion to dismiss this hearing because the petitioner has received the records requested.
Second that motion.
So we have a motion and a second. Any discussion to the motion? All in favor, say aye.
Aye.
Any opposed? Okay, the motion carries unanimously. So the next item on the agenda is Brady Eames and ULCT. It's hearing 2023-128. And Mr. Eames is requesting access to a deposit and investment report for January 1st, 2023 through June 30th, 2023. Access was denied due to a pending fee of $84.10 from January 2022. Rebecca is the petitioner.
Mr. Nick Jarvis is here for the respondent.
Nick, welcome.
Good morning. Thank you.
The way that the hearing proceeds is each party is we're allowing 10 minutes. And we start with the petitioner and then we go to the respondent. And Mr. Eames, I need to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. And Mr. Jarvis, are you an attorney?
I am not.
Okay. Will you state your full name?
My name is Nicholas Allen Jarvis.
And who do you represent?
I represent the Utah League of Cities and Towns. I'm the Chief Operating Officer and the Records Officer.
Thank you. And do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. So we will proceed. Mr. Eames, you have 10 minutes.
Okay, the record that I'm requesting specifically is required by law to be made under Utah Code Title 51, Chapter 7, 15. And I'll read it to all of you. Public treasurer shall file a written report with the council on or before January 31st and July 31st of each year. The report shall contain the information about the deposits and investments of that public treasurer during the preceding 6 months ending December 31st and June 30th, respectively, that the council requires by rule. Information detailing the nature and extent of interest rate contracts permitted by Section 51(7)(17)(3). A public treasurer shall make copies of the report available to the public at the public treasurer's business hours. Now, I'm Nick Treasurer. And that this report would be open for my inspection if I physically show up and request to inspect it. It's because I requested almost 100 of these from other participants in the PTIF. I'm pretty confident it's just a one-page document, and that it is being electronically stored, maintained by Mr. Jarvis, and that in 15 minutes or less, he could copy that to an email and send it to me. I also want to remind everyone that on April 29th, 1999, Utah Court of Appeals set forth the following precedent with respect to requests for public records. Finally, we suggest that sound public policy requires an agency, prior to compiling records and imposing a fee, to inform the requester that fees will be assessed, and if so desired, allow the requester to modify or withdraw the request based on the information. Certainly back on, I believe it would be back when Mr. Jarvis charged me the fee, he would have known about this court case that I'm well aware is supported by the counsel to the committee. Because on August 17th, 2023, that counsel, who was Brian Swan, advised the committee that a governmental entity has got to inform the requester of the fee first and give them choice whether they want the records and pay for them, or now withdraw and can't give the records and hold the fee as a weapon for future requests, so to speak. I want to inspect this particular deposit and investment report in order to ascertain whether or not the PTIF is being misreported as a certified depository, and also to ascertain if the interest rate pertaining to the investment of the certain public funds transferred to the state treasurer by Jarvis have been misreported. So it's a very fundamental public record that I think should be open for public inspection without hindrance of any kind of fees. And especially because I believe it's just a one-page record. So I'm requesting that the committee grant my appeal, that I not be obstructed by that past fee charge, and that the release of that record by email be ordered by the committee. Thank you.
Any questions for Mr. Eames?
I have one. Mr. Eames, did you ask for a fee waiver on that January 2022 request?
Did I request a fee waiver? Yes, that was stated in my request.
I mean, on the one that they're holding, the $84 on that one. Did you request a fee waiver of that?
Yeah.
And
yes.
Did you appeal the assessed fee?
I did not.
Thank you.
Any other questions? Okay, we'll go to Mr. Jarvis.
Thank you. So you received a statement from us on our position. I would like to correct something Mr. Eames had just said. On that request from January 28th, 2022, there was not a fee waiver requested. There was no fee waiver requested. A fee was assessed, and then it was not appealed. So I guess I'll start from the end rather than the beginning. Our argument is that Mr. Eames does not have the right to appeal not an access denial, which this is not, but the refusal to process a request because of an outstanding fee. GRAMO allows entities to deny access to public records for the reasons stated in 63G 2205. What we have done is not processed a request because of an outstanding fee under 63G 2203 8AII. So our argument is that the process that is occurring right now is for access denials, which is defined in Utah Code 63G 400.5. That does not reference this part of the code that we are operating under for not beginning to process a request. Mr. Eames is correct that the PTIF document that he is requesting is a public document, and we have provided him with those many times before he had incurred a fee. And any requests we've received since the fee has not been paid, we have not begun processing those requests. Essentially, that is the crux of our argument. There was no fee waiver requested. A fee was imposed. He did not appeal that fee. So he had an opportunity to request a waiver. He had an opportunity to appeal that fee. So we are not appealing the fee right now. The determination to be made is whether or not an access denial has occurred. And it is our opinion that it hasn't. We have not denied access. We have decided not to process until we have received payment for that fee. Thank you.
Thank you. Any questions for Mr. Jarvis?
I have
Nova.
one. Yes, Mr. Jarvis, did Mr. Ames ever receive those records from 2022? Did he ever pick them up?
They were delivered to him via the Open Records portal electronically. So yes, he did receive those records.
Okay, thank you.
Thank you. Any other questions?
So there was, I just want clarification on, so you did notify Mr. Ames that there was going to be a fee associated with that 2022 request. And he did not appeal, so therefore you went ahead and filled the request, provided the records on the Open Records portal for him to access.
Yes, we imposed the fee and provided the records.
Okay, thank you.
Did you notify him that there would be a fee before you filled the request?
The timing with it being within the portal, I'm not sure which is clicked first, the fulfillment or the notification of a fee, but I believe yes, the fee was first and it was fulfilled as part of the same process.
But isn't it that they have to notify him that there is a fee and given an opportunity to withdraw his request?
I've never seen the portal on the receiver's end, but on like the records officer end, you mark that there's a fee and it sends a mess. My understanding is, maybe, I don't know, for Becca or someone can jump in, but it sends a request telling him there's going to be a fee.
And that's
gives them an opportunity to appeal it, I assume.
Or to modify.
Is that-
I don't
before the
see their end, yeah.
So it doesn't release the record, because it seems like Mr. Jarvis is saying it essentially happened at the same time. But
it's kind of part of the same.
Right.
Yeah, and so when you respond about the fee, there'll be an automatic email sent answering that part of the request, which they can appeal separately, but they don't have to.
And then you can answer the request outside the portal. Like they can go and do the work, the compiling, and what the records officer needs to do. And
But they answered it inside the portal.
He's saying they answered inside.
And use the portal to communicate that fee.
So all of those steps are happening within the portal.
And I just haven't seen it on the.
But I'm not clear on the timeline from when they told him there was a fee assessed to when they provided the record. What was the length of time? Was there an opportunity for him to say, actually, never mind, I don't want to pay $84 for this? Mr. Jarvis, can you provide clarification on that? Was there an opportunity for within the portal, because most of us are not familiar how the portal works, was there an opportunity for Mr. Eames to say, never mind, no thank you, before you then filled the request? Or was it kind of an automatic process?
It was not an automatic process. I'm not aware of a stipulated time frame in which we need to let him know, because the fee is imposed based on the time actually spent. So the process has to be completed before we know what the fee is. Mr. Eames was in possession of our records management policy that states how we impose fees. So I don't know, this was 2 years ago, so I don't recall the time in between when we've notified him of the fee and fulfilled the request. It was a part of the same process within the portal, but the notification of fee happened first, and then the documents were uploaded to the portal.
Okay. Well, most entities that we deal with, they estimate a fee before they do the work, and that's what they send to the requester. But you're saying you do it differently. You basically do the work and then tell them there's a fee and this is what it's going to be.
That is what we did in this instance. We do not receive a whole lot of grandma requests. In fact, over the past 4 years, they've only been from Mr. Eames, and probably even going back further than that. So we did not have a process in place for estimating. We went and found the records he was looking for. I would also add there in my reading of grandma, it says that we can provide an estimate of fees, but not that we are required to estimate the fees.
Yeah, but it also says you can levy a fee, but you're not required to.
Yes.
It just seems to be the function of that in grandma is to give the requester an opportunity to say, never mind, that's more money than I want to spend on this request, or I can't afford it, or whatever. That seems to be the function of this part of the code. And I'm not saying what you did was incorrect, but I'm saying it doesn't allow for that time for the requester to say, never mind. But obviously, like you said, you have done the work. So that's what's confusing.
May I ask a question, Mr. Ames?
No, but.
So, Mr. Ames, did you download those records that were provided to you from the portal, from the 2022 grandma request?
Of course, to ascertain whether or not they were responsive.
Okay.
Maybe that's an implied consent to the fee. If Mr. Ames.
Well, I wouldn't interpret that to mean that.
So, Mr. Eames, if there's no more questions for Mr. Jarvis.
There's too many gray areas in Grom.
Yeah, there's a lot of gray area.
So, Mr. Eames, we'll come back to you for summation.
Okay. Right now?
Yes, please.
Okay. I would just really like the committee to start respecting and carrying out this Utah Court of Appeals decision, and then I guess it would be the policy position of Mr. Swan, that before the records are found and provided, that I be notified of a quote in order to exercise my right to respond that I can't afford it, and to thereby and thereafter, withdraw the request, modify my request, narrow it down so hopefully the records don't cost as much. But I want to get back to this deposit and investment report that, again, I'm confident is a one-page record in a file, an electronic file of Mr. Jarvis that he could click on, copy to an email, and send to me in 15 minutes. That is a very important provision of GRAMA, that if a record can be provided in less than 15 minutes, it shall be provided without any charge. But this past due fee is being used as a weapon to undermine that important provision, I think. And again, I'd like to see that Mr. Jarvis is respecting and obeying the State Money Management Act by having filed this report with the State Money Management Council and having in his possession to open for public inspection in either his physical office or on the website of the Utah League of City Towns. It's not online. So it's being denied my inspection. It's a fundamental public record, and all these participants in the PTIF really got to open up and reveal this report along with the statements of account that I'm requesting over and over and over again from the participants, because I've been ordered to do so by the committee, so that I'm not being accused of being lazy in researching where these records are revealed, and they're not revealed on office and request to inspect them, or I have to go through the formal process under drama. So trust me that I'm not lazy doing what I'm doing. If I don't see a record online, then I have to go through this process, and then we end up here. And you have to decide, is this particular one-page record a fundamental financial record that should be open for public inspection without the weapon of a past due fee being used that I never approved of before the records were provided? Thank you.
Thank you. Question, Mr. Eames from Nancy.
Mr. Eames, did you get a notification from the Open Records portal that a fee would be assessed? Because
no, they.
Go ahead.
I would have to, if that record has that record been provided to you?
Well,
Are you talking about
the reason I asked about the 2022 is because Grandma allows them to not process any future records. It's subjective. They get to choose if there's an outstanding fee, and that's why we're trying to get to the bottom of how the fee was assessed, so that we can use that in our deliberations as well. And that's why I just wondered if you had received something from the Utah Open Records portal telling you there would be a fee on that.
Well, if we're going to focus in on that old record, you're going to have to. Does Mr. Jarvis have the record? Do you have the record? Because I don't have the record being. Yes.
Thank you.
Okay, so with with the problems hearing him, Mr. Ames is saying he did not receive a notification through the portal that a fee would be assessed for 2022.
He doesn't know if he did.
He doesn't know if he did?
That's what it's 2 years ago. Okay.
Okay. Any other questions for Mr. Eames?
I've requested stuff through the portal, but I've never had fees, so I don't know who.
We'll come back to Mr. Jarvis for summation.
Thank you. To summarize, we received the request in January 2022. We did this all through the portal so that there was tracking of timing and what was received, and that there was kind of an external entity that would track that. There was no fee waiver requested. My understanding, even though I do not, as someone using the portal, I do not receive whether or not a notification went out. My understanding is when the fee was compiled, before it was completed, the notification for a fee, which is separate within the portal, happened first. Completion of the request happened second, and that he did not appeal this fee that was imposed, though he had the opportunity to do so. And like we said, we don't think that what he's requesting here right now is an access denial. It is refusing to begin processing requests until a fee has been paid. So our position is the timing happened properly. Everything was done properly. And we have decided we will not process future requests until we've received payment for this fee. Mr. Eames is absolutely correct that this is a one-page document. We've provided him with many, many of them before. It is a public document, and we are in no way trying to hide these documents or limit access to them. This is simply the administrative procedure that's allowed in Grandma, that if a fee is unpaid, that we do not have to process future requests until it is paid.
Thank you. Any questions for Mr. Jarvis? Hearing none, we'll go to deliberation.
Well, I did want to ask the questions because of Graham v. Davis County Solid Waste. You know, if they let him know that the fee was being assessed and just my experience with the portal is that happens before you ever upload records to the portal, but that's my experience.
Well, except in a way, Mr. Jarvis contradicted himself because he told me that they had to essentially fill the request to know how much to charge Mr. Eames. So I guess what I'm wondering, I mean, is a notification that a fee will be assessed enough or under the law, or does, like I said, most entities, they provide an estimate?
Graham requires the total amount.
Grandma requires the total amount.
Graham case.
Oh, Graham case.
Requires the total. You can provide an estimate, but at some point the total fee has to be informed to
Some point before the requester gets the record.
And well, I mean, I guess to me, if I separate the fee part out and I look at the type of record this is and how hard inspection is, and I mean, I have some questions about that in my mind as we're deliberating. Like,
When you talk about the record, are you talking about the latest record?
yes,
Or
I'm
the
talking
original
about the
old
request we're here for. The
Okay.
request we're here for.
Oh, okay.
And I know how easy it is to get, and there wouldn't be a fee. And so in my mind, I'm also considering the fact that just because it's on a computer and you can't come inspect it because you have to have a login to get to it. Like inspection, if there's a fee and there's an inspection of a record, like to fill a request is just to allow for inspection or at some work that actually gonna have to compile it. Do you understand what I'm kind of debating in my mind? It's just this doesn't, I mean, it is a records request. He didn't make it in writing, so I don't know.
Well, so Graham said you can't charge a fee for inspecting and examining the record if it has to be compiled, or if it's not going to be compiled in a form other than what it's normally maintained. So the only time, the court said the only time that a fee can be assessed for searching, examining, seeing if it's responsive is if it's going to be compiled in a form other than how it's normally maintained.
Well, and the way this is compiled is the treasurer logs in, clicks he wants that report, and he prints it off. But it's a login, so it's not like Mr. Eames could come and do it himself. And so.
So that would be your job on how to interpret that with
Right.
what the court said.
Right.
So you're saying that $84 is an unreasonable fee?
No, I'm not saying
No,
that at all.
that's 84 is the old record, not the one
Whether
you're
an
talking about.
inspection of a public record should be allowed regardless of the fee
Um,
issue. That's what I'm
That's what
saying.
you're saying.
Does that make sense? And I mean, and we've dealt with the DNI investments report and the PTIF reports. And in that code, it says it's public record that should be available in the treasurer's office. The treasurer's code says that. And so it, you know, is that like walking in saying, I want to see the minutes of such and such a date? Like, I'm asking what you
Well, did Mr. Eames request to inspect it? Or did he request a copy?
Good question. Like, I can't remember what he asked, so.
Mr. Eames, could you answer that? Did you request to inspect the newest record? Or did you request a copy of it?
He wanted an email.
I think he did.
Well, can you hear me?
Yes.
Yeah.
Can you hear me? Hello, can you hear me okay?
Yes, we can.
Okay. Through the records portal, I believe I had to indicate to inspect. Okay, I believe through the open records portal, I had to indicate to inspect and be provided a copy of it. Because if you're not down there at the physical office and you request it, there's only one way to be provided the record. Either you go to the site or you Google it, find it somewhere else besides the government's website, or it's by email. So, yeah, when you do an online, use the open records portal, basically requesting electronic records that can be sent through an email or accessed through the open records portal.
Thank you.
Okay. Hello? Yeah, you're welcome.
Chair, Mr. Jarvis has his hand raised.
Mr. Jarvis, did you have a comment?
Yes, I would just, the technology was kind of hard to hear there, but requesting an email of a copy of it. He has requested to inspect the records, and he's welcome to do so, under my understanding, if he were to, and the treasurer code that Nancy referenced, that he could come into the office and inspect them. That requirement, I don't believe translates to me having to provide a copy, right? That's the difference between a copy and inspection.
Thank you. So the unique twist to this one is the fee waiver was requested.
Or appeal.
Or appeal.
And we know he knows how to.
Yes.
And then if I look at Graham, it feels like through the, to me, it feels like through the open record portal that they let him know there was going to be this fee of $84.10. The question, you know, whether they got a response on that or not, you know, doing it through the portal, I don't know what happened, transpired after that.
But he has received the records.
Yes, he has.
For the first request.
Yes, he has. And he didn't appeal the fee. And it does, you know, through the portal, you are required to tell him before you do it that there's fee and what the estimated fee is, at least from my experience with the portal. So I feel like mostly they met Graham. I mean, whether there was a discussion about whether he wanted to request if the fee was too high. But he didn't communicate anything after getting notification of the fee, which he says he doesn't remember getting. So, but my experience with the portal is that they get a notification. Yeah. So I don't.
So the question I have is how long does this $84 fee hang out there for subsequent requests?
That's a good question.
And I don't know.
I mean, we're talking 2 years.
Sure. Is it within our authority to address that?
No.
Because the requester justified that that's a tool being used against him. And that's concerning to me. How long can that go on?
Yeah,
the
grandma doesn't
statute,
stay.
grandma doesn't help us with that question.
And it's a really good question.
If Mr. Eames can't keep track of what he owes, that I think that's his problem. And grandma does allow someone, a government entity, to require that fee to be paid.
I guess.
Can I, well, if Marie's
Thank you,
done.
Marie. Were you?
I'm done. Yeah.
I look at the vexatious laws and I know we're not talking vexatious person here. I'm talking about the maximum that they can go without making requests is a year if they're deemed vexatious. So like, and that's in the code, right?
So to
hold it over their head for 2 years, I just don't know, like.
So.
But there's a cost to governmental entities and I'm really sensitive to that as well.
Yeah, and I think the vexatious and the fee are completely separate.
Right.
Yeah.
I agree.
Yeah.
I agree that they're separate. I was just talking more about the time frame.
I know what you're talking
Like
about.
they,
Yeah.
they recognize there's a limit to keeping people from getting the records, or I mean, that's what, but I agree, it's totally different statute and didn't
But I
mean to
think
like.
it's a good, thank you for bringing it up, because I think I would be comfortable with a motion to deny this appeal, but I'm not comfortable with that fee hanging over the requester's head with this entity forever. Like,
But do we have the power to say it
that's the
can't?
question I'm
Yeah.
not looking at him to ask. Can an order include, to Nancy's point, the vexatious part of the code?
Well,
It allows this committee the authority up to a year to impose that.
I mean,
Okay, folks, hey, wait.
Go ahead, Marie.
I don't like this capitalist society we live in, but we do live in a society in which if you owe someone money, that if you know that if you can wait it out for 3 years, you no longer owe them. That world doesn't exist in the universe.
And I would just say that he had received the records. To piggyback on Marie, he received the records. He downloaded the records, and he knew there was a fee associated with it, and he did not appeal. He could have appealed.
We
He
need
downloaded the records.
To me, that suggests an implied consent to the fee. And if he consented to the fee.
When he downloaded the documents, he consented to the fee.
Yeah, that's kind of how I'm leaning.
Well, then I would make a motion to deny the appeal based on 63G2 203 fees. Paragraph 8, which allows a governmental entity to require past fees to be paid before beginning to process any future requests. Given that they did notify the requester there would be a fee prior to filling the order, the records were received and they were downloaded, and there was no appeal of that fee.
They have requested that you guys decide the issue of whether this justiciable order issue, if you can decide on this, because there is no formal declining, there's no formal action on his request.
Well, the statute, Grandma, that is very vague. And it seems like a lot of things come to this body to try and figure out when things are vague like that. So I think it is a legitimate function in this situation. Because the statute is so broad, I think it is appropriate for us to rule on this, is my opinion.
So there's two issues that they have asked you to review. One is the current request and the past fee. The second one is whether this can even be decided, because they haven't technically denied the request. It's in this limbo state that's in this gray area of grandma, right? Because it's due to a past fee. And they're like, we're just holding it. We haven't denied your request, but we're holding it until you pay this past fee. So is that technically a decline, a denial of the record request that now warrants the appeal? Or is it a non-denial? You guys don't have jurisdiction over it. That's what the entity is asking you to decide on this.
And
If you want to take up that issue.
And I would propose that in addition to requiring him to pay the fee, that we decide that we don't have a denial on this current. They're still willing to allow him to have it. He's just got to pay the fee. So I don't think we need to rule on the second one.
I don't know if I'm comfortable with that, just because.
But he can be, if we don't rule on it, he can always come back later. Because this is about the fee.
Denied the records on this particular grammar request. He has not been denied any records. That's what it boils up to.
Well, and you know, it's the definition of denial of records, because in effect, he can't get to the record until he pays the fee. So in effect, that's a denial.
No, that's not. It's just you pay the fee.
But what I'm saying is, if he doesn't pay the fee, he cannot get to the record, except to walk in and inspect it. He cannot get a copy of the record, I just say, to be correct.
It's not a denial.
True, because he could walk in and inspect it.
That's true.
And if we rule that is not a denial and he pays the fee, then
or is
for some
Utah
reason,
League of Cities and Towns saying we shouldn't rule anything?
that's right. That's what we're saying. It's not a denial.
So what do you do? Do you just dismiss that?
Default denial. Brady Beams made a request. They did not fulfill his request. He appealed it. I'm assuming they did not do anything with it, and so time frames are now into an automatic denial. Like someone makes a request, doesn't we just don't do anything with it? Is that not a denial? That's how I would interpret that. So I almost feel like it's a default denial because they haven't provided him the records that he made a request for.
Up to you guys if you want to take that issue on, but that's what the entity has requested, that you look at those issues.
Yeah, Mr. Jarvis, I'm looking at the thread here. He never provided Mr. Ames an opportunity to appeal this particular grammar request because there was no access denial. He just goes back to 2038. That's what he refers to.
Messes with that too.
Just back at all that you have 10 days.
Ed, could you speak louder? I can't hear you.
I'm just saying that even though he didn't say that your request was denied, I'm not sure if you have to, because after 10 days you have an opportunity to appeal to that person.
But he never did.
And then if he doesn't appeal to, or if that person doesn't ever respond back, then you have enough opportunity to appeal here.
But he never denied this grammar request. The one that's before us, he never denied it. And so there was no opportunity for Mr. Ames to actually appeal a denial because it wasn't denied by the chief administrative officer.
But they don't have to respond, do they?
But Mr. Jarvis did respond. He kept the communication going. He just said, you need to pay this prior fee, and then we can move on and process this records request.
CAO, could they not just keep the line of communication open forever and never? But if you have a time frame to be able to request, you don't fill it within a certain amount of time. Since 10 days is matter.
But if
it's an automatic denial.
He
No,
did
it's
not
not.
deny it though.
It's not denied. If he pays, okay.
It's an implied denial of denial. It's a de facto denial of denial. Or do you actually have to?
You have 10 days to fill this request. If you don't fill it, no matter what communication is taking place, it's a denial, is it not?
I tend to agree with Ed.
No, it's not a denial. He pays the fee. He goes back, says, okay, give me my request. If at that point there is a denial, then that's when the denial kicks in. And that's when the 10-day kicks in. He has not done a denial.
So might I suggest we have Nancy's motion right now on the record for the current issue, right, with the appeal. This issue, if you guys take it on, would actually need to be decided on before hers, because this will determine if you have jurisdiction to decide the current appeal. So I would suggest.
So for now, I'll remove my motion.
Withdrawing.
Okay. So Marie's argument is saying we don't have jurisdiction. Ed's argument is saying we do.
Just reading that language. Cool.
I mean, I don't think that we have the authority to wipe out a debt because it's been too long. That's not what we do. We decide whether or not the fee is appropriate or whether or not there's a public need. So it's not within our authority to say whether or not they can charge this fee, except to recognize that GRAMA allows an entity to not fulfill a future request if there is a fee waiting. Isn't that correct?
So I think, can I just read parts of the code here, just because of what Ed brought up? So a governmental entity shall review each request, that's the expedited one, as soon as reasonably possible, but no later than 10 business days after receiving a written request, or 5 days receiving a written request if the requester demonstrates that expedited response to the record request benefits the public rather than the person. 1, approve the request and provide a copy. 2, deny the request in accordance with the procedures and requirements of 63G2205. 3, notify the requester that it does not maintain the record. 4, notify the requester of any extraordinary circumstances. And then paragraph 9 says, if the governmental entity fails to provide the requested records or issue a denial, that would be one or the other, within the specified time frame, that failure is considered the equivalent of a determination denying access to the record. So I'm just going to go here to 63G205.
Which is what happened. Yeah.
If the governmental entity denies the request in whole or part, it shall provide a notice of denial to the requester, and it shall include, what it needs to include. So, I mean, that says, I understand Ed's question. It's like, if they don't approve or deny, it's considered a denial. But that's how after the 10 days, that's how I read the code.
No. Because they didn't deny, because they said you can have access to it, but you have to pay your fee.
I'm just saying they are denying it because they didn't provide the record that was requested.
I know, and I disagree. I'm sorry.
But I do agree.
Why don't you do a motion, Ed, and let's decide.
In a day.
Yeah, Ed, do a motion and we'll see.
I do agree with you, Marie, though, that I'm very comfortable leaving the fee out there forever until it gets paid. I think you have to pay it. We're definitely on the same page with that. I am.
Well, and the other thing, it's a slippery slope. If we decide 2 years is too long, what happens if somebody comes in the future is like, well, 1 year is too long? And then we get, well, 6 months is, you know.
No, I just want to say that I put that out
We
there.
don't want to.
Yeah. So, yeah, but what I'm saying is, you know, what time is, you know, appropriate. The
Until
law
you
doesn't
file
say.
bankruptcy. That's the way it works. You file bankruptcy and you negotiate your debts. I mean, the government isn't any different than any other organization.
I agree. I believe we have jurisdiction because I believe it's in effect a denial. Now, on the other issue, I haven't decided.
Michelle
Okay,
Kruger.
I'm not making a motion.
We'll help you, Ann. Yeah, you'll have to help me with the codes then.
Well, I'm with Linda. I think we do have jurisdiction.
Yeah, I do too. It's 2049.
Then I would make a motion to deny the appeal that the governmental entity effectively denied the request.
For the second part. The new request.
And that the new request doesn't need to be fulfilled until the fee is paid based upon 2038.
I would second that motion. Rebecca, did you get that?
The motion is to deny the appeal. The entity effectively denied the request under 2049.
2049.
2049. And the new request does not need to be fulfilled until the fee is paid per 2038.
Okay, we have a motion from Ed and a second from myself. Is there any discussion to the motion? Okay, we'll start with Marie.
Okay, I'm gonna, I actually agree with the outcome. I just
hold
don't.
1 second. Marie, hold
Yeah.
1 second.
I just got a notification with the email chain showing that he was not notified of the $84 fee on February 11th. If that changes anything, I'm just bringing it to your attention.
Oh, hold on. February 11th.
2022.
2022 request.
Okay. Yeah, that makes a big difference to me if he was not notified.
He's saying he was not notified of it.
That's
Mr. Ames.
That's Mr. Eames saying that.
But we don't know.
It's a copy
We
of
need
the-
evidence of that.
Well, Brian has an email chain he sent to
an
him.
Email, he copied everybody.
Oh, did he?
Well, Ken, Nancy, and Marie have it.
Okay,
He's saying that that's his position that he did not receive.
okay, hold on.
It was in the port. If it was in the portal, he would have received
Yes.
a notification.
Yes. Yeah.
So what does the email chain say? Is it just an email from him saying, I did not receive notification? Or is there some evidence from him?
It's an email chain is forwarding from Nick Jarvis to Brady Eames and email chain.
The portal doesn't produce an email chain like that.
No,
does
this
it?
was a direct.
There's
He
a.
does. And he does write back, Mr. Eames writes back and does appeal the $84 fee. Well, this was back.
Oh, it was back when it was.
Yeah.
So he did
I don't-
appeal the fee.
For me, this doesn't change my support of your motion, Ed.
Respectfully, if could I have a chance to respond if he's going to introduce something in the middle here?
That's why I said I don't think this changes Ed's motion or my
It
second.
may mine, so I would appreciate Mr. Jarvis's clarification if that's okay.
Yes, please go ahead, Mr. Jarvis.
Not seeing the email that he's just now provided. There is within the portal and outside of the portal. The notification occurred within the portal, and then my emails informing him are outside of the portal. So I do not believe, not seeing this email in front of me, that any email that I did outside of the portal would be proof that I did not notify him within the portal of the fee.
Thank you. Any other comments or questions?
Can I see the email?
Yeah, I'd like to see it too.
Yeah, I will
Post
forward it. Or actually, yeah. I'm going to put it in the file.
Okay, thank you.
You putting it on the drive?
It's not from the portal.
It's not the portal, it's just Mr. Eames providing testimony.
Actually, I'm not because I can't. It's things aren't gonna work. So.
Could you also tell me the date of that email just so I can see it as
February
well?
14th, 2022.
Thank you.
This is just their policy, and this is an email to Mr. Eames. That's the.
Looks like
I would also just add that this email, he does state that he shall appeal, but he never followed through on that appeal. He did not appeal this fee.
Rebecca, where did you put it?
I just forwarded it.
Oh, it's by email?
Yeah,
Okay.
computer doesn't want to make a PDF for some reason.
Oh, that is the one that is me.
I didn't get it.
With the BP media.
I can make that.
Ah. Rebecca, you sent this resolution?
It's the email itself that he's referring to. The resolution is just when they adopted their fee schedule. The attachment, the emails themselves.
Scroll down.
Yeah.
Yeah, oh, okay.
We have a motion before us from Ed and a second from myself. Ed, does this change your motion? No. Doesn't change my second.
Could you read the motion again, please?
Can you read the motion, Rebecca?
Yeah. The motion is to deny the appeal. The entity effectively denied the request under 2049. The new request does not need to be fulfilled until the fee is paid under 2038.
Any further discussion to the motion? Okay, hearing none, we will take a roll call vote. Marie.
I appreciate the extra time. That email provided me to think about Ed's motion, and I am going to vote yes.
Linda.
I think I'm going to vote no because it is unclear whether Mr. Eames had the opportunity initially to say, never mind, I don't want you to fulfill the request. So for that reason, I'm going to vote no.
Thank you. Nancy.
Aye.
Mark.
Aye.
Nova.
I believe that Mr. Ames was provided, I'm just reading through this on February 14th, that he was given an opportunity to appeal, even though he did not initially, I guess, request a fee waiver. I'm not clear on that, but it doesn't look like the appeal was followed through. So I'm going to vote aye.
Ed, and I vote aye. So the motion carries 6-1. Mr. Eames and Mr. Jarvis, the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. Either party may appeal to district court within 30 days of the date on the order. So thank you for your time. Committee, do you want to hear one more before lunch? What time is it? It is 11:30.
Yeah, sure.
Can we saunter for just 2 minutes, please?
So excuse me, but since I have to leave at noon and I'm not sure you'll be done by then, I'm going to sign off.
Great.
Okay.
Thank you, Marie.
Okay.
See you, Marie.
Okay, just 2 minutes. We're gonna saunter Rebecca for 2. Okay, the next item we are going to take up is we are going to change the order on the agenda and we're going to hear Brady Eames versus West Valley City, hearing 2023-124. And you're from West Valley City?
Yeah, Melinda Bowen from Snow Christensen and Martinell on behalf of West Valley City Heat today. Thank you.
And Mr. Eames, did you hear that? We are going to go with the West Valley City hearing.
Oh, he's muted.
You're muted.
Is he there?
Mr. Eames, are you there? You're showing muted on our end. There you are.
Yeah, I have to move around this little cursor and find that little icon. So I found it. Okay, I'm here.
All right. Did you hear that we were going to do the West Valley City hearing next?
Yeah.
All right, if you're ready, you have 10 minutes.
Okay, this case involves the same kind of deposit and investment report. As today, though, I have still not received a written appellate statement from West Valley City via first-class mail. So I want that noted for the record and as hopefully a default. That West Valley City be ordered to provide me the record, but based on what I've submitted so far, I think you understand that I'm being denied records for not paying a fee quote. And I've never been provided the records I requested. And again, this is a vital financial record that I know is electronically stored and that West Valley City can access just by a click or logging in, as Ms. Dean has mentioned several times, and then just emailed to me. So I don't have to spend money and time driving down to their physical office to inspect the record. But again, I was never provided in the past that they are wanting me to pay a fee for. And I would like the committee to keep in mind the Utah Court of Appeals that we've been referring to today, and also the policy statement of Mr. Schwan that using a threat or using a fee quote not paid. I don't know how better to explain it, but if I haven't paid a fee quote and then deny me future records, is got to be totally illegal. And I hope the committee recognizes that and will order the release of this public positive investment report that reveals important information about the public funds that have been pooled in the PTIF and invested by the public treasurer. As you know, I'm trying to obtain from all the participants to carry out my due diligence, as you guys have advised me, because it's not online, this record. Thank you.
Thank you. Any questions for Mr. Eames? Hearing none, we'll go to the respondent.
Thank you. And thank you again for hearing us before lunch. Mr. Eames is correct that this is very similar to the last matter that was addressed before the committee with a couple of key differences. First of all, this was not done through the portal, so we submitted all of the correspondence between West Valley City and Mr. Eames as exhibits to our submission that we provided last week. In those submissions, we have specific emails in which in 2019, and this raises the question, I mean, this is many years ago, 4 years ago, but Mr. Eames reached out and requested records. The West Valley City Assistant City Attorney responded by stating, okay, we deny your expedited request and we're reserving the right to assess a fee. He then responded again and indicated to Mr. Eames what the fee, at least at the beginning stages, was going to be for the first part of the work that was done by the recorder's office, which was an hour and a half of work on behalf of one of the employees there. Mr. Eames responded, or I should say, Mr. Jepson, who was at the West Valley City Attorney's Office at the time, also stated, if you'd like to provide more information concerning the reason for your fee waiver request, I'd be happy to reconsider. Mr. Eames did not respond to that invitation to discuss the fee waiver request. And Mr. Jepson then told Mr. Eames the total amount of the fee once all of the records had been collected. And it was approximately 300 pages of records that were collected by employees at West Valley City. So Mr. Jepson informed Mr. Eames of the total fee, which was $49.03, and stated that the record would be released via email or Dropbox if that fee was paid. Mr. Eames responded with a request for additional information, and when West Valley City asked if that was an additional GRAMA request, it received no response. So Mr. Eames did not follow the process provided in GRAMA by which he could state, okay, with that fee, I withdraw the request, or to appeal the fee waiver denial. And so the request was outstanding. The fee was still in place without an appeal of that fee that was imposed. And the records were just waiting for Mr. Eames to accept them. And it is the case that he did not accept those records. And that does make it slightly different than the previous request where he accepted records without paying the fee. But the fact remains that Mr. Eames did not follow through with the process of appealing that fee, waiver denial, or withdrawing his request for the records. And the work had been done by West Valley City employees at that point. And the records were available to Mr. Eames if he wanted them. This was communicated to Mr. Eames in May 2019 when he made another request for records at that point, and West Valley City told Mr. Eames, we can't process a request for records from you because we have this outstanding fee. That response to Mr. Eames' request in May 2019 was not appealed in any way to this committee or otherwise. Then in 2023, August, 30th of 2023, Mr. Eames submitted his current request for the report that he's mentioned. I'm not familiar with the process. It sounds as if members of the committee are more familiar, so I'm not sure what it entails to process that request and get the records. But the West Valley City Attorney's Office responded by stating that it wasn't even going to begin to process the request until the fee was paid, which is permitted under section 203, subsection 8A II, as the committee's already talked about. And so the city was proceeding as it was provided in the code. And Mr. Eames responded by stating that, or by quoting the section that allows for public inspection of their treasurer's report, which we don't dispute. He can come and view the report in the treasurer's office anytime he'd like to come in person. And then he requested the appeal information, but he never actually appealed the fee waiver denial or the 2019 decision, or what may be a de facto denial here to the chief administrative officer or anything like that. He simply went ahead and appealed here to the State Records Committee. So even if there may have been a de facto denial, there hasn't been any appeals of the decision before this point. And we would just submit that the decision not to go ahead and process the request was provided within GRAMA, and West Valley City was proceeding according to the language that was provided there.
Thank you. Any question for the respondent?
I just want some clarification. So West Valley City began processing the initial request in January 2019 before Mr. Eames had a chance to respond and say, no, I don't want to pay fees. Is that correct?
That's correct. So they sent an email to Mr. Eames saying we reserve the right to charge fees. After the first about half of the work had been done, the West Valley City attorney emailed Mr. Eames and told him this is about the cost that we've incurred so far, but that doesn't include what the I'm trying to remember what the other half of the work would be, because there was another office that needed to gather records in addition to what had already been done. Mr. Eames never replied to that communication as to how the fee was kind of progressing. And that was on January. The first communication about the first half of the fee was January 22nd, 2019. And then another 6 days passed with no communication from, oh wait, excuse me. Mr. Eames did respond and say, before I pay any fees, please provide me with the following. I take that back, I apologize. And ask for that information. In response, 2 days, or that same day, Mr. Jepson asked him if he's making an additional request for records based on what he had requested in terms of information. And then stated the total amount of work that had been done. So you are correct that in the interim, Mr. Eames had not responded. West Valley City continued with the work to provide the records that had been requested. So within that 6 day period, West Valley City hadn't heard anything from Mr. Eames, but as soon as he requested additional information, West Valley City followed up on that.
And is that normal West Valley procedure when they get an initial request that is going to require more than a few minutes work?
You know, I'm not certain on that, to be totally candid with you. But I imagine that as the prior respondent noted, West Valley City is not sure what amount of work is actually going to be required until you start into the process. Okay. And I think once it goes beyond that initial 15 minutes, maybe they start the process and then give an estimate, but I'm not totally sure on the process, to be candid.
Any other questions for the respondents? Okay, hearing none, Mr. Eames will come back to you for summation.
This is tricky because if I don't respond when I get a fee quote, then it's open, I think, and I would assume West Valley City would be perfectly okay with leaving it open for me to get back to them at any time to approve the fee. But I don't think because it's open, like it's an open request, that I should be denied inspection of this one-page record that, like the Utah League of Cities and Towns, Mr. Jarvis said, well, come on down to the office. I'll let you look at it. request a copy of it, am I going to get this denial of a copy of it there in the office? Or if I choose to bring down a scanner, my own scanner, and I say, well, I'd like so I can make a hard copy record, are you going to let me do that? Or, use a smartphone to take a picture of it. And then I walk out exercising my right to take a copy of a record that should be open and is open for public inspection according to West Valley City and their physical office. But it's silly because, like I said before, a click on electronic file, this record, a one-page record, and then just sending it to me in an email would save me money and time. It would save them the time of having to look for the record when I get down there. And I imagine when I would walk in and ask record, they'd look at me funny and go, I don't know what you're looking for. I'm going to have to consult somebody in the office to find out where that record is. It's supposed to be in the public treasurer's office. But would it be readily available at that time, or would that public treasurer have to run to his computer and then print it out and then bring it out to me? Let's be reasonable here with respect to a vital financial bills where West Valley City has deposited probably millions and millions and millions of dollars in public funds to be invested by.
Any questions for Mr. Eames? Hey, hearing none, we'll come back and respond.
I would just add, I think I'll just reiterate or echo everything I said before. But BRAMA does provide a process for Mr. Eames to get back to West Valley City and say, I withdraw my request, and he never did that, and he never appealed the denial of his fee waiver. And so as far as West Valley knew that request, he still wanted those records and the fee was still in place. And that had been communicated in the past to Mr. Eames. And with that, I would just reiterate that, or I would actually add that GRAMA doesn't necessarily make clear how to handle a situation like this where there is a pending fee, but the records haven't been picked up. But the fee was nonetheless imposed and it wasn't ever appealed. And so I think that West Valley City was proceeding under the language of GRAMA as best as it could in the situation.
Thank you. Any questions for the respondent?
I have a question.
Yeah.
Just clarify for me why, when there seemed to be some miscommunication on the fee, and I think that there seemed to be, we emailed him and told him, then he sent another email, and there's this miscommunication going on. Why West Valley City would continue to work on the request until that was resolved? There's additional fees that happen after that point.
Right, so it actually wasn't, so I may have misstated. So Mr. Eames on January 22nd, on January 22nd, Mr. Jepson indicated what the first half of the fee was going to be. There was no response from Mr. Eames in response to the invitation to, we can talk about the fee. There was no response from Mr. Eames until the 28th. And by that point, the rest of the work had already been done in the meantime. And the response from Mr. Eames maybe that signaled a miscommunication about the fee, but before that, West Valley City didn't have any indication that Mr. Eames was going to contest the fee.
And then how was he supposed to get these records that he has a fee for?
As soon as he paid the fee, they were available via email or Dropbox.
Yeah.
Okay, with no further questions, we'll go to deliberation or a motion.
Just looking at this, I actually have a question, if that's okay, Ms. Bowen. Yes, of course. Did Mr. Jepson on January 2nd, did he email him saying it will cost the 22, 27, or we have already done some of the work and so far it has cost?
He stated up to date, West Valley City has incurred reasonable costs in the amount of $27.83 minus the first 15 minutes. And if you'd like to discuss that and give us a reasoning for why that fee should be waived, please reach out.
Yeah, and I would really prefer these government entities to just respond back and say, we feel this is going to be more than 15 minutes and it's probably going to have a fee, rather than starting the work without express permission. Having said that, I do believe that Mr. Eames' email where he said, before I pay any more fees, please provide me with, is implied consent for the fees. Because he could have said, wait a minute, I'm not going to pay that 22, 27. Let me withdraw my request. But he knew that, but they even said it 1.5. So he had a good idea of how much he would have to pay. And instead of saying, no, don't go any further, he said, before I pay any fees, let me ask for additional things. So to me, that's an implied go ahead.
Are you reading that section from January 28th? That email? Is that where you, because that's what I'm looking at.
Oh, I was looking at the statement of facts from
the
respondent.
Yeah.
Yeah, January 28th. I'm looking at is the emailing different to any different?
No, I believe it's the same. I'm just looking at the email threads.
Yeah. So to me, it's a little bit different than the last, just because he did have an opportunity to say, no, I'm not going to pay the fee, which is like obviously embarrassing.
Any other comments?
I think I'd like to make the motion to deny the request. We could use the same citations as the last motion, I think.
But they did. Oh, yeah.
That the request is effectively denied under 2049 and the new one doesn't need to be filled until the fee is paid under 2028.
Yes.
I'll second that motion. With that, say that I appreciate you making the distinction between this one and the last hearing. Where I'm a little more impressed with West Valley's communications.
Yeah.
I mean, and it's imperfect. Like, this process is imperfect.
Right.
I thought they demonstrated more of an effort by the entity to allow the requester to adjust, withdraw, or agree to pay the fee. Any discussion to the motion?
I just had a question. So has West Valley compiled all the rest of the records to total the $49.03? Are they all together now, ready to be dropped into the box?
They are. They're still available. I have
a
full PDF.
Okay, I just wanted to make sure it wasn't just the portion, the first half.
No,
the whole
full amount.
Okay, all of them are compiled. Got it. Thanks.
Thank you for that question. Any other questions? Okay, hearing none, we will take a roll call vote. Nancy.
Aye.
Aye. Ed. Aye. Nova.
Aye.
Linda.
Aye.
And I vote aye. So the motion carries unanimously. So for the parties, the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And then either party may appeal to district court within 30 days of the date on the order. Thank you for your time.
Thank you so much.
Okay, we will take a break for lunch for 30 minutes. Is that enough time, committee? Okay, so we will be back, Rebecca, at 12:35. Yep. Okay, I'll call the meeting back into open session.
This meeting is being recorded.
And the next item on the agenda is Brady Ames versus Lieutenant Governor. It's hearing 2023-127. And Mr. Eames is requesting a fee waiver for 3 bill signature sheets. And Mr. Eames, can you hear us okay? Brady, can you hear us okay?
Can you hear me?
Yeah, we can hear you. Hold on just 1 second.
Hold on, I'm trying. Yes, I can hear you. Can you hear me?
Yes, we can hear you. Hey, we know Mr. Eames, but the respondents introduced himself.
Hi, I'm Mallory Underwood. I'm the
Okay.
office administrator at the Lieutenant Governor's office.
You're the office
Administrator.
administrator.
And I'm Colin Sanner. I am the Grandma Officer for the Lieutenant Governor's office.
Well, welcome. You were here for the prior hearing, so you know how this goes. So before we get started, I need to swear you in. So do you both swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes, great. Thank you. So Mr. Eames, the time, you have 10 minutes. Mr. Eames, I need to swear you in.
I would like to. Yeah, I was going to ask for a clarification because I don't think I've been sworn in on every one of these hearings.
Yes, I neglected to do that. For this hearing, Mr. Eames, do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Great, thank you. So you have 10 minutes. Please go ahead.
Okay, I'm going to give you guys a break. This case doesn't pertain to the records of the state treasurer, or the public treasurer's investment fund, so you'll probably be kind of relieved about that. This case pertains to fundamental legislative records and executive records, which are required by the Constitution and law to be made. Okay. And they're not online in the website of the legislature or the governor or the lieutenant governor. So I haven't been lazy in trying to locate these records so I can inspect them, and the only way that I'm going to be able to do that is through the formal GRAMA process of requesting them, waiting for decisions, and unfortunately here we are in another appeal hearing because there's a staff time fee that's obstructing my inspection of these records. Each of these official signature sheets will reveal wet signatures of the following public officers: the presiding officer of the Senate and the House, the signature of the governor, and the signature of the lieutenant governor. And I would hope that the legislature and the governor and lieutenant governor support and defend my constitutional rights as a citizen of Utah and a governmental watchdog to inspect these official signature sheets. The laws that are cited, or the bills that are cited in them, have actually become laws of Utah. And in the appellate statement of the lieutenant governor, I believe you're being misled to believe that if you just go online to the website of the legislature and look up the status information, that's equivalent to these official signature sheets that show the wet signatures that are required by law. And that's not the case. Why they're not online is a big mystery to me. My opinion, they are the proof that a bill has been to a law that is governing me and every other citizen of the state of Utah. I've been provided these or other official signature sheets in the past without any staff time fee charge, but all of a sudden, it looks like there's going to be fees associated with being provided official copies, electronic copies of these records. Now, if I were to go to the down to the lieutenant governor's office to inspect them, hopefully I would be able to do that. But that's a mystery. I don't know if that's possible. The decisions you guys have made with regards to the deposit and investment reports, I'm being led to believe that I can go down and inspect public records in an office and then without being hindered by any kind of fee before I inspect them. But obviously this is another case of, well, we're going to charge you to inspect an electronic copy of this record that has been emailed to you. I want to end this saying that the record management policy that the lieutenant governor attached to their appellate statement records, those have never been duly proposed to the public for comment, and they're not codified in the current Utah Administrative Code, so I don't see how they can govern what the records officer of the lieutenant governor is doing. I've also been provided no proof that the executive officer of the lieutenant governor's office has approved this fee. So my appeal stands, and I request that the committee order that they're in favor of that fee so that I can inspect these absolutely fundamental records that prove the bill has been enacted into law. Of all records that the public should be able to inspect without being hindered by fees are these records. Thank you.
Great, thank you. Any questions for Mr. Eames? Okay, hearing none, we'll go to the respondent.
So I'm just kind of going to go over the statement of facts that was sent over. For the factual background, this records request was submitted to our office on September 1st via email, and it requested the signature sheets of the 2020 SB 111 Higher Education Amendments, 2021 SB 181 Department of Government Operations, and 2023 SB 146 Higher Education Governance Amendments. On September 7th, we responded to the request for the signature sheets by requiring a fee of $43.75 on the grounds that the request did not meet the criteria for a fee waiver. On September 13th, Brady Eames submitted an expedited appeal to the Chief Administrative Officer, me. On September 27th, I responded as the Chief Administrative Officer, affirming the denial of a fee waiver request based on the lack of appropriate reasoning for a fee waiver. And then on September 28th, Brady submitted this appeal to the State Records Committee. So for our argument, Grandma does permit a governmental entity to charge a reasonable fee to cover the actual cost of providing records. When calculating the fee to cover the actual cost of providing the record, it is that the hourly rate may not exceed the salary of the lowest paid employee who is in the discretion of the custodian of records, has the necessary skill and training to perform the request. Given the state of purpose of the records request and the time Mr. Tanner spent in an effort to search for and retrieve the records, the Lieutenant Governor's office requested $43.75 and denied Mr. Eames his request for fee waiver. Colin Tanner is the records officer as approved by the Utah Division of Archives and Records Service and oversees initial responder duties associated with Grandma with the Lieutenant Governor's office. His hourly rate is $26 an hour. Upon receipt of Mr. Eames's request, Mr. Tanner searched and obtained for the responsive records, which were not maintained in the custody or possession of the Lieutenant Governor's office. And the entire process took an hour and 45 minutes. With removal of the first quarter hour of staff time from the fee total, that came to $43.75. The petitioner could not show or did not show to us that the request primarily benefited the public rather than himself. In accordance with Utah Code 63G22034 and the Lieutenant Governor's Office Grandma fee waiver policy, we require that a requester seeking a fee waiver based on a claim of public benefit demonstrates that the request would primarily benefit the public. The petitioner's only basis for asserting that the request primarily benefited the public rather than himself is that as a citizen of Utah and resident of Cache County and Logan City, concerned with the administration of higher education within Utah and other government operations in Utah, he has a constitutional right to inspect the records. Our office holds that being a citizen of Utah does not give the petitioner the inexhaustible right to submit an expedited Grandma request, which places an undue burden on the Lieutenant Governor's office. And demonstrated in the statement of facts, Lieutenant Governor's office reasonably exercised its discretion to assess a fee deposit based on the petitioner's failure to show that his request primarily benefits the public and to account for the administrative time applied to respond to the request. And because the Lieutenant Governor's office's decision to deny the fee waiver was reasonable and based on consideration of appropriate factors, and the amount of the fee deposit is a reasonable estimate of the direct costs to the Lieutenant Governor's office in fulfilling the petitioner's request, the petitioner's appeal should be denied.
Thank you.
That's it.
Any questions for the respondent?
Yes, probably Mr. Tanner. Mr. Tanner, right. Ms. Underwood said that the records were not in the Lieutenant Governor's office's custody. Where physically are the records located?
Archives.
Archives.
Yeah.
Archives?
They've been transferred to the archives.
Okay, all right. Okay, thank you.
So did you give Mr. Eames an opportunity to amend his request or to send him directly to the archives for retrieval of the records?
I believe, so I would have to double check our records. But I wasn't aware that you could submit a request to archives. I thought that was done through our office. It's kind of like a proxy situation. So like they would request, we would reach out to archives, get those records, and then I would take that scan and then send it over to the requester.
I think for clarification, they're at the Archives Record Center and they're still right custody of the agency. So they request them from
Right, so they have to go pull them off that shelf and
they are still in.
And then they have to come back to the office where you then.
Yes. They're not on site.
So if he were to inspect them, they would request them and have them available to him at their office? Okay.
So our reference services will provide them in our research center.
Okay.
Because they're not in our archives custody.
Okay. All right.
Was he given the opportunity to modify his request or withdraw it based on the fee, or how did that?
That's a good question. Usually the responses that I send don't include, I thought that was kind of more or less granted. When we send a fee request or fee, request, we're kind of asking them to, understand that this is their request, this is what they're asking for, and to either provide payment for the records or just resubmit a request altogether. I can't remember exactly what the language was used, but I would assume that it was implied that a new request could be submitted for different records from our office.
So have you done the work yet? You have those records?
Yeah.
Any other questions? Okay, hearing none, we'll go back to Mr. Eames for summation.
It's news to me that these records were actually maintained by archives, because what could have happened is I could have withdrawn the request when I found out I was going to be charged $43.75 by the lieutenant governor and requested directly from archives. But I wasn't provided that direction. So here we are today. I'm sorry, I couldn't hear you.
Mr. Eames, I just wanted to clarify, the records are being stored.
I can't hear you.
Can you hear me now?
Can you hear us,
Yes.
Mr. Eames?
So for clarification, the records are in the...
Yes, but I'm not finished with my...
Right, I will allow you to finish. I just want to clarify for your benefit that the records are still in the custody of the Lieutenant Governor's office and they are stored at the Archives Record Center. So the respondent is correct in that the access to these records has to go through their office. These records are not in the custody of the state archives. So go ahead.
Okay, I would like to... I'm okay to go ahead?
Yes, please.
Okay, I would like to know if there's a retention and classification report that specifies where these records have to be requested from. Does the Office of the Lieutenant Governor have a retention and classification report that, reveals, okay, these records are in our office, but we have to request them from the archives? Is that what's going on here? Is we got two different governmental entities involved in locating the records, and then archives is responsible for some kind of transmission of the records to the Office of the Lieutenant Governor, and should I have appealed to the archives also this denial of the fee waiver? Because obviously two governmental entities account for the maintenance of these records, and together it's resulted in this fee. And I'd like to know where it's specified that these two parties have to work together in order to release those records to the public if they're electronic copies are requested, or if the public wants to inspect hard copies. The Lieutenant Governor. stuff being implied. This is really bothering me, that decisions that are being made, I'm supposed to read between the lines that something is implied. That's absolutely unreasonable. And you don't look at laws and try to discover what they imply. It's the text of what is in print. I think it's news to me again today that the archives was part of this process in finding these records and making sure that a decision was made and that the records were provided within 10 business days. And then also the fee that was associated with it. Thank you.
Thank you. Are there any questions for Mr. Eames? Okay, hearing none, we'll come back to you for summation. You have 5 minutes if you want to respond.
I think ultimately this decision of the State Records Committee needs to hinge on whether or not they believe that the signature sheets that Mr. Eames has requested are beneficial to the Utah population, and that any requester who's requesting those records from our office can do so to get electronic copies of them without a fee. I think that's the crucial point in this argument, and just curious to see what you guys decide.
So for clarification, let's just be clear and on the record. These records are still in your custody. They're stored at the State Records Center.
Correct.
And when you received this request, you requested them from the Division of State Archives. And the records came back to your office, and you made copies, and those copies were there for him to pick up or pay the fee and receive electronically.
The copies were made by the State Records Committee, or the Division of Archives was the only difference.
Which is a service that they provide.
Right.
It's a scan and deliver service that we provide to any governmental entities.
And in the past, we've provided these records to Brady Eames. He mentioned earlier that we've provided them in the past without charging that fee, which is true. The only difference in that is Mr. Eames provides the grammar requests to our office in a really unique way, in that he doesn't go through the online portal that we've set up to help the public and for our office to help organize and track those requests. He'll just directly send it to me via email, or whoever is the what's the word? The officer on our website. So it's made it a little bit difficult, and because of past delays that we've experienced with these requests, that's why the first request that he submitted for other signature sheets in the past has been waived. But we've decided with this request that we're currently discussing that it would be an undue burden on our office to just, whenever we receive records requests for something like that, to go out of our way, and specifically go out of my way, and kind of neglect other duties as assigned to kind of be a personal records retriever for Mr. Eames or whoever else is requesting those records. So we've considered it to be in our office's best interest to charge for that time. And yeah, that's why we didn't charge in the past.
Thank you.
Can I ask a question?
Please.
So, Mr. Tanner, so one previous request or more than one previous request for Mr. Eames?
To my knowledge of one previous request for, I think, 2 or 3 signature sheets that had to go.
Okay. Okay.
Any other questions from the committee? Hearing none, we'll move into deliberation. Would anyone else, or would anyone like to make a motion? Just one comment. I just think I'm impressed that the Lieutenant Governor's Office has their records management policy. It's quite impressive. And it's a year old. So I wish more agencies would have an airtight, not an airtight, I shouldn't say that, but have a policy and procedure for the other thing that they alluded to is that they have an online forum for making requests to their office to help the public interact with the office.
I have one question. When, do you mind, Chair?
No, please.
So when you denied the fee waiver, had you already gathered the records from the archive storage?
Yes, to my knowledge.
I think we've had some discussion about this in the past as well, that it does cost for governmental entities to store and work with records.
I thought the respondent spoke to that, saying that, you know, in the past, they provided these records free of charge. And then I can't remember Mr. Tanner's words exactly, but they weighed that against the other work that the office had to perform.
So I guess I have a question.
Please.
Mr. Tanner, did you notify Mr. Ames of that? Essentially that the office had changed its policy.
Well, no, in that our office never changed the policy. I kind of saw the first request, the neglect that our office had for that request in not responding to it in a reasonable time because of the fact that it was submitted via email and not through the online system that we've set up to kind of give those records initially as kind of a olive branch, if you will. And then when additional requests came in, once again, not through the dedicated records submission portal that we have online, it kind of occurred to us that if we were going to keep receiving these records requests from Mr. Eames, we can't rely on the precedent of, you know, fulfilling those free because, you know, we get a lot of records requests. I have other duties as assigned. Anytime that we receive a request from Mr. Eames, I'm not going to be able to just go out of my way and fulfill that without there being some sort of compensation related to that was our determination. So that explains for the previous one, but I was never clear and upfront with Mr. Eames in explaining that there would be a change from that first request to the next requests in the request for compensation by our office due to my once again, assumption that that was kind of clear in grandma code and that we are able to, or records officers are allowed to waive fees as they deem necessary or fitting for this situation. So no, to answer your question, I was not clear to Mr. Eames that there would be fees to be charged for future requests.
Okay. So obviously, you know, according to grandma, you've done everything according to grandma, but you can understand, you know, Mr. Eames made a request, received them without any fees, to then next make a similar request and be assessed fees, that it would have been a surprise to him. Tell me how it works if people make the requests through the online portal. Is that something that takes less of your time? Is that?
Exactly. So that's something that I've completely set up on my own, working with our office's attorneys. That and the office policy that we've set up, that's all kind of my doing. So that the records portal mostly just allows requesters to input all the necessary fields with their name, with their contact information, what they're requesting exactly, you know, the description of the records, if they're requesting a fee waiver or not. And it automatically puts all that information into a Google Sheet that I'm able to track a lot better. It sets up the deadlines, depending on if they want an expedited response or not. Just helps me out a lot. And so whenever Brady Eames or Mr. Eames has submitted a request, I've always requested that he redo it through the portal just to make it easier for our office and easier for us to, you know, remain on top of deadlines and stuff like that. But Mr. Eames has neglected to do that and instead submits via email, which is fine, but in my opinion, it would be a lot easier for everybody involved if we could just do that situation, but that's why that was created.
So if he had made this request through the portal, would it have cut down on significantly on the time it took you to fulfill the request?
Not the time it would take me to fulfill the request, but the time it would take to draft correspondence and recognize that the request had come in. I mean, I receive a lot of emails, a lot of spam emails daily. Mr. Eames is, no offense to him or anything, but the email that we received kind of looks like a spam email, which gets filtered out by my computer software. So it would be a lot easier for us to initially receive the request and sort it and be able to draft those responses and things like that. If you would submit it through the records portal or the submission portal.
Okay, thank you.
Any other questions? There a motion?
I make a motion to deny the appeal in accordance with 203(8) that the governmental, oh, wait a minute, hold on. I withdraw. Hold on. No, if you want to jump in, Mark, go for it. I just want to make sure I have the right one. Yeah, I think that's what I had written down before. So I make a motion 2034.
It must have compiled the staff time compiling formatting.
Yeah, that's two. Yeah, we could do two. Yeah. So I make a motion to deny the appeal in accordance with 2032. Governmental entity, when a governmental entity compiles a record in a form other than normally maintained by the governmental entity, actual costs under this section include the following. So yeah, that's my motion.
We have a motion from Nova. Is there a second?
I'll second it.
And a second from Mark. Any discussion to the motion? Okay, hearing none, we will take a roll call vote. Linda.
Aye.
Nancy.
Aye.
Ed.
Aye.
Mark.
Aye.
Nova.
Aye.
And I vote aye. So the motion carries unanimously. So for the parties involved, the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And either party may appeal to district court within 30 days of the date of the order. Thank you. Thank you for your time. Okay, the next item on the agenda is Brady Eames versus Lehigh City. It's 2023-125, where Mr. Eames is requesting access to a deposit and investment report. Respondent did not answer the or Rebecca.
Wood will be online.
Mr. Wood, can you hear us okay?
I can. Can you hear me?
Just barely.
I'll scoot a little closer.
Okay.
And I apologize. It doesn't seem like my camera is working, but at least I'm on audio.
Yeah, that's okay. Perfect. If you were here for the prior hearings, what we do is allow each party 10 minutes for a presentation and then 5 minutes to sum. And we start with the requester, so that will be Mr. Eames. So if you don't have any questions for us, we will move forward. And Mr. Wood, I need to swear you in.
And I also have our finance director here with me. His name is Dean Lundell. So you should probably just, I don't know if he'll be asked to speak, but you might want to swear us both in just in case.
Okay, so Mr. Wood and Mr. Lundell, do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Yes. And Mr. Eames, do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Mr. Eames, can you hear us? Brady, can you hear us?
Go through this with
The issues on his end, no one else is having a problem hearing. So this is nothing they can do.
Mr. Eames, we can't hear you.
James, do you want to try calling in? It's webinar, so I can't call out.
Mr. Wood, do you want to hold on while we try to make contact with Mr. Eames?
Yeah, that would be fine.
Great, thank you. Rebecca, can you, oh, he disconnected, so let's see if when he comes back in, we can hear him.
I'm voting against her. Same initials.
So while we're waiting to connect, let's do a couple business items. So the committee members' attendance for the next meeting.
I'll be here.
I gotta check that date.
February.
22nd? Or is it 15th?
Yeah.
15th. Linda? On the 15th of February.
Yes.
Nancy's a yes. Mark? Yep. Maybe. You're maybe. Nova?
Yeah, I should be here.
That'll be here, so we'll have a quorum. So we'll check with Marie.
Mr. Eames will not be returning.
He won't?
No. I just got an email that says, I protest the audio of your hearing today. I have left the meeting.
Okay, so
I protest the audio.
And apparently he's been having trouble hearing, but it's not on our end. So there's nothing I can do to help.
I always advise against moving forward without a party present because of due process issues. So you can, if you'll dismiss it, I would suggest carrying on that.
Yeah, because I have a, guys, like,
please.
So if the entity, if convinces us that they've done a reasonable search, then it falls to him to convince us they didn't. And so I don't see how we could proceed without him, right. Especially in this case.
So would you be suggesting a continuance, dismissal, or denial?
Asking me.
I'm asking the committee.
Does he want to continue this?
That report, they're going to tell you. I think either a continuance or a dismissal is, appropriate.
Okay, I'll make a motion to continue the hearing to next month.
I'll second it.
Okay, I have a motion to continue in a second.
Could I ask a question really quick?
Yes, please.
And so I may be able to make the next, I think you should probably have your motion to continue, but I did notice in the context of some of other Mr. Eames' requests, under the section that says basis for his appeal, he says he requests the deposit and investment report. That we could easily give him. His original request was for each and every fund, trust, indenture, or other indenture that pertains to the external public funds deposited into the PTIF. We just didn't know what that was and didn't have any records that we thought was responsive. I'm happy to reach out to Mr. Eames in the interim. And if what he was really after was that deposit and investment report, we can give that to him, and maybe it will mean that we don't have to come back.
Great. Thank you, Mr. Wood. We would appreciate that. So I still stand by my motion to continue.
So stand by my second.
Nancy stands by her second, and hopefully they can resolve this in the interim. So all in favor of the motion, or any discussion to the motion? Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed? Nay. Okay. Brian, the next item on the agenda, cases in court.
Not much happened since 2 weeks ago. I said that 2 weeks ago. So Jeff Benyon's appeal has been final judgment and dismissed. So that is officially closed. And Paul Amon, as you know, he filed an appeal on the order regarding, it was the case with the AG's office where the records were at different agencies. So that one is a new appeal as well. Those are the only new developments, right? That is scheduled for a hearing on February 26th. That is an in-person hearing at 2 p.m. at Matheson.
You'll be representing the committee there.
The 26th.
26.
What time?
2 p.m. Courtroom N42.
You said February 26th.
Yep.
Which is a Monday.
Maybe one. I expect there will be an audience there, especially a bit media. Salt Lake Trib is interested in the case. They filed a supplemental brief on that. So.
Any questions for Brian? That was everything on the agenda. Correct me if I'm wrong.
One thing to raise, it's not necessarily a business item because it doesn't require a vote. The SRC's recent rule revisions are now out of the public comment period, and we didn't receive any.
I've not received anything.
That is on the agenda.
Oh, so we'll see it on this printout.
Oh,
it's on the back.
Yeah. So nothing new to report on.
No, we haven't gotten any comments. Just become rule.
So we'll file to finalize those.
Wonderful. Thank you. Okay. Does anyone from the committee have anything else? Looking for a final motion.
Move to adjourn.
All in favor of adjourning, say aye. Aye. Any opposed? Okay. Thanks, everyone.
Please take it back.
We finished in record time today. Just saying.